Good morning everyone. This is our sentencing reteach for the work we did the last week of term. So from marking your assessments, it's clear that we need to go over a couple of things. So I thought the easiest thing to do would be to record this video and then take you through the tasks that I need you to have a go at. Then there's another task at the end for you to have another go and see what improvements you can make. So there was a couple of you-do tasks that I asked you to complete. The first one was to create a table on the types of sentences and how they fitted in with what our aims of sentences were. So all you needed to do was list some of the types of sentences available in the UK and which of the aims they link to. So the example I gave you, that fines may be a deterrent, and it might be effective in terms of some people may be able to afford the fine, some people may not be able to afford the fine, so it may not actually deter people from doing that. And then you needed to do the same sorts of things with other types of sentences. I wanted you to then tell me which types of sentences were available for youths, which were available for adults, and why there was a difference between them. And then I wanted you to use the sentencing guidelines for ABH, which you can find on the Sentencing Council website, and use this step-by-step guide to work out a sentence for the case scenario that I gave you. So we're going to go over a few of those bits today, and then I'm going to give you another task to do. So this is what you should have created for the first task. So we've got our types of sentences. We have linked them to the aims of sentencing, which we discussed on that lesson, and then we've commented on whether or not they're effective. So for example, got custodial sentences at the bottom. They work as a deterrent for people. They work in a deterrent as two ways, so they deter people from committing crimes in the first place, and if people experience a custodial sentence, that will act as a deterrent for them to not offend again. They work as protection for the public because if we lock people up in a jail, then they are not free to commit any more offences, so we're protecting the public while they're locked away. They work as retribution. The victim feels like something has happened to the offender for the bad things they've done to them. And hopefully they also work as rehabilitation, as people who are undertaking a custodial sentence can take part in some rehabilitation work while they're there, whether that's education or a drug or alcohol programme or some counselling. So then when we consider whether they're effective or not, we need to consider whether they meet those aims of sentencing. So when we talk about a deterrent, it only deters people who have a lot to lose, people who are homeless or have no job or have drugs or alcohol problems might actually prefer to be in prison because it's a safer environment for them, so it won't act as a deterrent for those people. In terms of protection for the public, it only protects people if the violent offenders are given long sentences or indeterminate sentences with whether they can be extended. That doesn't happen very often. Retribution, the victim can feel that some vengeance has taken place, but if they don't feel that the sentence has been long enough or harsh enough, then they may not be effective. And in terms of rehabilitation, if it's a very short sentence, a couple of weeks or a couple of months, then that isn't enough time for any rehabilitation to take place. It has to be a longer sentence for a course, an education course or a drugs or rehabilitation course for it to take place. And if the prison is particularly overcrowded, then no rehabilitation can take place at all. So those are things that we need to consider when we consider if they're effective or not. Do they actually meet those aims that they are put in place for? The next task that I want you to go back to and have another go at is using the sentencing guidelines. Now the sentencing guidelines are put in place by the government and the Sentencing Council, and they are to ensure that all judges and magistrates are giving sentences out equally across the UK and across courts. So what I wanted you to do was have a look at the guidelines for actual bodily harm and then have a go using them in a scenario. Now actual bodily harm is what we call a tariff sentence, so there will be a minimum and maximum set out for the sentence that can be given, and then the judge or the magistrate would need to consider aggravating factors or mitigating factors when deciding if they can increase from the starting point or to reduce the sentence down to a lower starting point along that tariff. I gave you a scenario which was a quite a basic actual bodily harm scenario. I had put some few things in there that would make you think about aggravating and mitigating factors, and it was designed to get you to see how those steps could work in increasing or reducing the sentence. On the left of the screen is the magistrate sentencing worksheet that I sent you, and as you can see, there's step-by-steps that will take you through what you need to do to decide on a sentence for the crime. On the right hand side is a screenshot of the website that you need to use. So this is sentencingcouncil.org.uk, and it's the magistrates guidelines for setting out a sentence for this offence. When you log on to the site, you can click on the menu on the left hand side and search through the offences and can find actual bodily harm. Now this links together two offences, which is assault occasioning actual bodily harm, which is the one we're interested in together, that's section 47, and the racially or religiously aggravated ABH, which is section 29 of the Offences Against the Person Act. There's a lot of information on this first page and it should be familiar to you. So we've got the name of the Act of Parliament, the Crime and Disorder Act, and the Offences Against the Person Act. We've got the date that these sentences are effective from, so we can make sure that we are using the most up-to-date sentencing guidelines. It tells us it's a triable either way offence, so we could choose the magistrates guidelines or we could use the Crown Court guidelines. And it then gives us a maximum sentence that we can give. So for a section 47, which is what we're interested in today, there is a maximum 5 years of custody. For a section 29, which is the racially or religiously aggravated ABH, then that's a 7-year custodial sentence. So as you can see, that carries a harsher sentence because of the aggravating factors. The offence range, which is the tariff bit that we were talking about, the range is from anything from a fine up to 3 years in custody. So that's the tariff, that's the range that we're interested in today. And these steps are going to take us through where on this sliding scale we're going to end up for our offence here. Okay, step 1 is to determine the offence of the category. So there's 3 categories, 1, 2 and 3, and as you can see they are variations of how much harm has been caused and how much culpability that the defendant has. So this is about responsibility. How much responsibility does this offender have in this crime? So the first thing we'll do is we will work out how much harm has been inflicted. So the factors indicating greater harm are injury, which includes disease transmission and or psychological harm, which is serious. Victim is particularly vulnerable because of personal circumstances, or there's been a sustained or repeated assault on the same victim. Factors indicating lesser harm is injury which is less serious. So although we don't have a very serious injury, it does have consequences because of the work that Donald does. And we could also say that because this harassment has been going on for a long period of time, this could be a sustained or repeated assault on the same victim. So we could put that in a category of greater harm. We then need to consider the culpability of the offender. So there are some statutory aggravating factors, so factors we must take into consideration. And these are if the offence was motivated or demonstrating hostility to the victim based on their sexual orientation, or if the offence was motivated on any disability. So in this case, we don't need to consider those. There's nothing in the scenario to suggest those. We can look at the other aggravating factors. So was there premeditation? Was there use of a weapon? Was there intention to cause serious harm? Was there deliberately caused more harm than necessary? Was there a vulnerable victim? Was the person a leader in a group or a gang? Or was there any motivation because of age, sex or gender identity? So we could take into consideration the fact that Boris was the leader of a large gang. That could put us in the higher culpability category. Lower culpability is if the person who did the attack was a subordinate in a gang, if there was a greater degree of provocation than normally expected. So has Boris done something to, has Donald done something to provoke Boris? Is there lack of premeditation, or is there a mental disorder or learning difficulty? So this one's a little bit harder because we've got some things to put higher culpability, some things to put lower. Once we've decided on the starting point, we can have a look at the category range. So if we decide this is a category 1 offence of high culpability and high harm, then our starting point is 1 year 6 months custody, and we can go anywhere between 1 year and 3 years custody. So we need to have a look at what things could perhaps reduce the sentence and what things could increase the sentence. If we decide it's category 2 because it's high harm but low culpability, then it could be 26 weeks in custody, and we could go for a low level community order anywhere up to 51 weeks in custody. There are lots of factors that the magistrate can take into consideration to increase that sentence or decrease the sentence. There are some statutory ones that they have to be considered first of all, and these are previous convictions, the offence was committed whilst on bail, or if the offence was targeted towards an emergency worker, so that would be police, fire or ambulance crew. So we could take into consideration the previous convictions. The other aggravating factors, there's a big long list, so location, timing, the effect on the victim, the failure to comply with current court orders, and any other offences taken into consideration. You can see there's a long list there. The factors reducing the seriousness, the mitigating factors, also need to be taken into consideration, and that is things like if there's no previous convictions, if it was a single blow, if the offender is particularly remorseful, if they lack maturity, or if they have any sort of learning disability, or if they are a sole carer for dependents at home. So you would need to jot down if you want to take into consideration any of those, and if you think any of those would reduce or increase the sentence. The next steps are ones that may or may not apply. You need to run through them and see if they need to apply. So any of the factors that would indicate a reduction, such as insistence to the prosecution. So has your offender been particularly helpful in bringing to court other members of the gang, or have they passed on any particular information that's been helpful? That might reduce the sentence. Have they put in an early guilty plea? The earlier that guilty plea goes in, the more their sentence will be reduced by, and that's potentially up by 1/3. Do we need to consider the dangerousness of the offender? If we do, if they're particularly dangerous, we can talk about extended sentences where they will only come out on parole if they meet certain criteria. We can also consider the totality principle, where we are going to think about other offences that we might need to take into consideration, and then also any compensation or ancillary orders. So do we need to arrange for compensation to be paid to the victim? Okay, nearly at the end. So step 8 is to write down the reasons why you've come to this conclusion. And these are all the other bits and pieces that you've put in there. It's really important that a magistrate does state the reasons why they've come to this conclusion. This is why they're different to a jury member, because the jury members don't have to put this in, the magistrates do. Then lastly, you need to consider any time that's been spent on bail. So if your offender has not managed to get bail and they've been remanded in custody until their offence has come to court, then that time can then be taken off the sentence. So it can be dealt with as time served. And that should lead you to your final sentence. So you should have decided on a starting point, and then you should have gone through those step-by-step guidelines to see if there's any way you could reduce the sentence or increase it. So depending on where you decided to start from, have you stuck to the starting point, or have you managed to reduce the sentence or increase the sentence? On to the you-do then. So this is your new scenario to have a go at, using those step-by-step guides that we've just been through. I want you to do exactly the same here with Rita. What sentence do you think Rita should have? What mitigating factors and what aggravating factors are they? And then email that back to me please as soon as you can.